Your Honors. My name is Keith Watson, and I'm here with my teammates Keely Linger and Austin Chakowski, and we are here to address the questions for Unit 1.
Introduce your teacher, please.
And Mr. Bader.
Well then, let's get down to business, shall we? We are, as we've said here, Unit 1 judges. We're interested in the philosophical and historical foundations of the American political system. We're asking question 3. In what ways, if any, can the Magna Carta be associated with the concept of rule of law and constitutionalism? Why has Chapter 39 of the Magna Carta proven to be of continuing significance? What important principles did it proclaim? Evaluate the argument Publius makes in Federalist 84 that bills of rights such as Magna Carta don't belong in constitutions founded on the power of the people. Here, strictly speaking, the people surrendered nothing, and since they retain everything, they have no need of specific reservation. Please begin.
FDR once said, "The democratic aspiration is no mere recent phase in human history. It was written in the Magna Carta." The concept of constitutionalism is the use of a written, an unwritten, or a partly written constitution and rule of law to empower and limit government. Our constitutional democracy cannot exist without rule of law, the modern concept of which originated in the Magna Carta, which is the principle that those who govern and the governed are subject to the same laws. It was established by an agreement, a contract, between King John and feudal barons, which recognized the king as sovereign, but limited his rights by guaranteeing the barons certain fundamental rights. The Magna Carta was an early example of a constitution, outlining the basic functions of government. Chapter 39 of the Magna Carta not only provides rule of law, but also for due process, largely through trial by jury, which is significant because it prevented the monarch from serving and placing his subjects at the peril of his whims as judge, jury, and executioner. The Founding Fathers prevented these actions by establishing rule of law and providing a fair trial through the trial rights and due process clause found in the 5th and 6th Amendments. The protections in Chapter 39 contribute to limited government by preventing the government from acting arbitrarily or tyrannically.
Chapter 39 also divested the sovereign of power, making a jury of peers the finder of fact in many cases, which, combined with the law of the land, were all that could imprison English freemen. Trial by jury was praised in Alexis de Tocqueville's Democracy in America, as it fosters civic education, participation, and self-government. The principles in the Magna Carta are now embodied in the United States Constitution, with due process, trial by jury, and rule of law being protected respectively in the 5th Amendment, 6th Amendment, and the important check of judicial review. Alexander Hamilton wanted a strong central government and was less concerned with limited government than other founders. He believed that instead of granting liberties to individuals, a Bill of Rights would restrict the operations of government, making it too similar to the government under the Articles that did not have enough power to effectively govern a nation. In Federalist 84, he said, "The Constitution is itself a Bill of Rights." Though Madison advocated for a limited government through separation of powers and checks and balances, Hamilton was concerned that by granting specific rights, the people could be denied a right that was left out. He emphasized that the people surrender nothing, and as they retain everything, they have no need of particular reservation.
John DeWitt countered Hamilton's 84 argument, Anti-Federalist Paper 2, stating that no language could be precise enough or too redundant in guaranteeing rights for Americans. Him saying the party to be governed cannot be too explicit. John DeWitt also wrote that a Bill of Rights would protect against tyranny resulting from failure to specify what rights were reserved to the governed. Hamilton's argument is disingenuous, as he said government should not enumerate rights in case something is forgotten, but also mentioned that the Constitution is a Bill of Rights because it has enumerated rights. He was concerned with avoiding a government too limited in its power. The Bill of Rights has protected enumerated rights of individuals from opportunistic politicians who have sought to erode them. An example of this is in D.C. v. Heller, when a Washington, D.C. law attempted to ban its residents from owning handguns, restricting the people in that jurisdiction from enjoying their enumerated right of keeping and bearing arms in the Second Amendment. Since this right is in the Constitution, the Supreme Court was able to use judicial review to review and nullify the unconstitutional Firearms Control Regulations Act of 1975. By providing the people rights, limited government is ensured.
Thank you.
Well, thank you very much. Since you've presented such a well-formulated argument, let me throw a wrench into your discussion and challenge the basic premise. It can be argued, and has been argued pretty widely, that the Magna Carta is vastly overrated in significance. That it was produced under pressure, that it was ignored almost immediately, and pretty much forgotten for the next 200 years. And so perhaps we simply resurrect it for our convenience. How would you reply to that argument?
I don't think that the Magna Carta overlooked much, and I think that it did provide the provisions in it of jury of your peers and the due process of law and rule of law that it did provide, even though it was only to the barons, and in that aspect wasn't necessarily contributed to all of those in Britain. It did help to establish a social contract initially and gain rights for people.
I wouldn't disagree with all of that statement, but really no matter when the foundation is made, it's important that it was made. So even if it was ignored almost immediately by King John, it came back, and those fundamental principles and rights of due process and trial by jury and rule of law are in our government today and are widely appreciated in the Parliament as well in their unwritten constitution.
Let me I'll throw this one to you. Had there been no Magna Carta, would England have developed the rule of law?
I think that eventually that popular sovereignty would have won out, and I think this is shown throughout England's history and how they've revolted many times to gain their rights. But I think that the Magna Carta was important in making that happen a lot faster and establishing the precedent that the king's power can indeed be limited, and that rule of law is an important thing to apply first to the barons and then eventually to the people through subsequent pieces through subsequent documents such as the Petition of Right.
Thank you.
In your opening statement, you've mentioned judicial review several times. That obviously was not contained in the Magna Carta, was it? Where did you mentioned constitutional judicial review? Where did that come from? How did that idea arise in our society?
Well, judicial review was a big part of the colonies at the time of the Declaration of Independence in the Constitution. And therefore, at the time the Constitution was drafted, 7 of the 13 colonies had judicial review in their constitutions, and all of them practiced judicial review in their courts. So it was ingrained in our nation at that time, and then was incorporated into our Constitution.
Was there a U.S. Supreme Court decision?
Of 1803, of course, Marbury versus Madison incorporated judicial review into the federal government.
And I think
I'd like to establish a little bit more about how you think about the Bill of Rights. We have free speech is in the First Amendment. The 13th Amendment abolishes the right to own slaves. And we have 2 amendments that abolish the right to purchase alcohol and then reestablish it. So those are 4 amendments addressing 3 rights. Which of those, in your thinking, would be the more fundamental, and are any of those alienable as opposed to inalienable rights?
I think that the most important of all those rights is the right to free speech, because it's through our free speech that we've expressed our popular sovereignty and worked to obtain more rights, as well as take them away, of course, through the amendments both restricting and then allowing again alcohol. I would say that if any of those rights are discardable, that would possibly be the right to consume alcoholic beverages. It was an essential part of the American culture. However, I don't necessarily think it's important to maintaining our foundations of government, and I don't think it's a foundational part of American culture that we couldn't go without.
And in addition, the 13th Amendment freeing slaves, I believe that right to liberty for all people in the United States as described in the Declaration of Independence with equality among men, but that the 13th Amendment, that right to liberty is now inalienable because it's so entrenched in our country.
With the right to free speech, I think it's important to remember the West Virginia versus Barnett case, which had the competing interests of religion and free speech, and what the limits should be on that, where the right to have speech or to determine not to in reference to having to say the Pledge of Allegiance in schools at the beginning of the school day, with religion being another factor for those who aren't allowed to make pledges or oaths, is another thing to remember, that the right to free speech isn't necessarily what you can say, but the right to not say something.
This was also exemplified in Texas v. Johnson, which shows the inalienable right to free speech.
Are we missing any rights in our Constitution that we need to add? Or do we have it perfect?
I believe that the Constitution could be a little more specific in enumerating the right to privacy. I think this is a much larger issue today than it was at the time of the Constitution's writing, as the term privacy was built off of the term privy, which actually referred to the act of going to the bathroom. Whereas nowadays, with all of our technology and informational sharing and networking that we have amongst ourselves, I think that privacy is more important than ever, especially with programs such as the National Security Administration. I see my time is up. May I briefly conclude my answer?
Sure.
Especially with programs such as the National Security Agency peering into seemingly all aspects of our social lives.
Thank you. That was a strong point on which to end, so I'm glad you were able to get that in. Very nicely done. I liked your beginning with the FDR quote. I tried to throw you a curveball at the very beginning, and you were quite willing to take a swing at it, and I think connected with it very well. And you were very conversational in tone and in the whole presentation, which I very much appreciated.
Thank you very much.
Thank you.
I would echo my colleagues' comments. I was particularly taken, and maybe because of my background with the course, but how you were able to plug in case law relevantly to the discussion of these kind of ancient precepts. So I really enjoyed that, but also your ability to think on your feet and express your own views based on your research and based on your experiences. I really liked it to hear, well, I think this or I think that, or this is what we can do to our Constitution. So good job all the way around.
I would strongly echo that. We all know a lot of stuff, and being able to think in addition to knowing stuff is where we want to get to. And I thought you did a very nice job. What I thought was a rather tough question, comparing different things. You might have expanded on the 13th and said, well, it really wasn't even an alienable right to own property. We just got it wrong and then eventually got it right. But nonetheless, you made the comparison. I think the right to buy alcohol or not is not as important as free speech. You might have elaborated a bit whether we would have had free speech as they do in England without an amendment. But you gave a very good idea that we might need to strengthen privacy. It's usually a lot of people say, well, we have our Constitution and it's so wonderful, it's perfect. Maybe not. Maybe we need to strengthen this or take back that or whatever. So it was a thoughtful idea to bring forward at this time. So I very much appreciated your presentation.
Thank you.
Thank you. Thank you, sir.
Congratulations.
Well done.
Thank you.
Thank you. Where is your house?
It's in Albany.
Thank you, Alan.
Thank you.
Thank you very much.
Thank you, sir.
Thank you.
Okay, nice job.
All right.
Nice job, guys.